Good morning. I hereby call to order this 19th meeting of the Pennsylvania Public Utility Commission and ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. For those of you that are joining us today at our hearing, I want to please ask you to please take note of the exits down the stairs on either side of the hallway outside of the hearing room. In a true emergency, a PUC employee in an orange vest will be there to help those who may need assistance. Once you move down the stairs, please exit onto North Street. Also, for your convenience, the restrooms are located on the atrium level near the cafeteria. We also wish to inform you of some security changes that will be taking place next year at the PUC entrance here at the Keystone Building. Effective January 2nd, public access to the third floor will not be available via the elevators. There will be one security guard that will be stationed at the main lobby on the second floor only. All visitors to the commission must take the main elevators to the second floor and sign the visitor log book. Visitors, including those with a Commonwealth ID, requesting access to the PUC bureaus and offices will be required to have an escort by a staff member. If no guard is present, visitors are asked to access phone listings to the right of the window. And once again, these changes will take place on January 2nd. I'm not going to ask you if there's any questions to that. Let's move on to our first matter on our agenda, and that is the approval of the minutes for November 8th, 2017. Let me first say that we need a change to our agenda because we have Commissioner Sweet as the editor, and it's actually Vice Chairman Place that is the editor. So I will say to the commissioners, without any objection, we will make a change to our agenda to have Vice Chairman Place as the editor. I don't see any objections, so by consent, we will make that change. So I look to Vice Chairman Place as the editor of the November 8th, 2017 minutes.
All right. Got to appreciate pomp and circumstance. I've reviewed the minutes of the November 8th, 2017 public meeting and move that they be approved as submitted.
You have heard the motion for the approval of the minutes. Is there a second?
Second.
Second by Commissioner Sweet, who was down as the editor of the minutes by mistake, but thank you anyway. Any edits, discussion? Hearing none. All those in favor of approval of the minutes say aye.
Aye.
Any opposed? The motion passes 5-0. And next we will move on to our agenda for today, and I will call up our Director of the Office of Special Assistance, Cheryl Walker-Davis, who will lead us through this morning's agenda.
Thank you, Madam Chairman. Good morning, commissioners.
Good morning.
May it please the Commission, we will be presenting recommendations from your various bureaus for your consideration and disposition. Madam Chairman and Commissioners, I would note for the audience that previously we identified the motions and statements at the time that the case was presented. You will be identifying your own motions and statements as we move forward. With that having been said, we'll start on behalf of the Commission's Bureau of Audits. And we do recommend that the Commission adopt the recommendations to release the various audit reports. With regard to the first four items, that pertaining to the release of the audit reports in the matter involving PECO Energy Company's Universal Service Fund charge for the noted 12-month period, as well as the audit reports pertaining to the Metropolitan Edison Company, Pennsylvania Electric Company, and Pennsylvania Power Company default service support riders for the noted periods.
You have heard the recommendation from the staff on these four items. Is there a motion on the recommendations?
So moved.
Is the motion to adopt the recommendations, is there a second?
Second.
Second. So motion by Commissioner Sweet, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
We do recommend the adoption of the release of the audit report in the matter involving the West Penn Power Company's default service support rider for the noted period.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Sweet. Is there any discussion?
Yes.
Vice Chairman Place.
Thank you very much. Madam Secretary, I ask that my statement be entered into the record as if I had read it in its entirety. Before the Commission is the Bureau of Audit's report on West Penn Power Company's default service support rider for the 12-month periods ended March 31st, 2016 and March 31st, 2015, and the 10 months ended March 31, 2014. The audit reports conclude that West Penn undercollected $10.9 million on reconcilable revenues of $19.3 million in 2016 and $5.6 million on reconcilable revenues of $11.3 million in 2015, equating to an error of 56% and 50% respectively. These undercollections resulted in significant interest charges to customers. For the 12 months ended March 31st, 2015, interest of $397,742 was charged to its customers, and for the 12 months ended March 31, 2016, interest of $788,094 was charged. The biggest discrepancies of actual versus budget DSSR charges is in the transmission enhancement charge category, specifically for the Regional Transmission Expansion Plans, or RTEP, and Trans-Allegheny Interstate Line Company. West Penn claims that their forecasters had no way of knowing the level of authorized transmission enhancement projects and that would be approved by PJM for the subsequent planning year for RTEP and TrailCo, and used the latest available actual information to budget for the following year without any advance information from the PJM planners. Given that one of these transmission companies is their regulated affiliate, I question these assertions. Secondly, PJM initiated a process to improve the transparency of transmission investments approved in the PJM planning process. Specifically, the PJM Transmission Replacement Processes Senior Task Force initiated development of a transmission cost information center. I strongly encourage West Penn to avail themselves of this information to improve the forecast used to estimate reconcilable charges to customers. Failure to do so will continue to impose costly interest charges on captive customers. Thank you.
Thank you, Vice Chairman Place. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
On page 2 of the public meeting agenda, still with regard to matters presented on behalf of the Bureau of Audits, it is recommended that the Commission adopt the Bureau's recommendation to release the audit report with regard to PPL Electric Utilities Corporation's Universal Service Rider for the noted period.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Commission's Office of Special Assistance, commencing on page 3 of the public meeting agenda, it is recommended that the Commission adopt the recommendations in the first 2 items through and including the matter pertaining to the UGI Utilities, Inc. Petition for approval of changes to its Phase 2 Energy Efficiency and Conservation Plan.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the staff recommendation in the matter involving the complaint of Jody K. Butts versus Columbia Gas of Pennsylvania, Inc.
Is there a motion to adopt the staff recommendation?
So moved.
Commissioner Sweet moves. Commissioner Kennard graciously seconds.
Yeah. Good resolution.
Good resolution. He is much louder than you are. I just have to tell you that.
That's a test. I can't compete.
Any discussion? I do have some comments that I would just like to state for the record. The complaint in this case was dismissed with prejudice due to the complainant's failure to appear at the hearing to prosecute her complaint. Before us for consideration is the complainant's petition, which argues that because she had never had legal representation, the case dismissed should be rescinded. In this case, proper notice of the hearing was given to the complainant. Therefore, I support dismissal of the case for failure to appear. However, as you have heard me say before, I do not support dismissal of the case with prejudice for failure to appear absent a showing of abuse of the process by a complainant. I see no such abuse in this record. I have previously expressed concern regarding the Commission's practice of dismissing per se complainants with prejudice as being inconsistent with Section 1.2 of our regulations and the Commission's own case precedent regarding due process. So I just reiterate those concerns today. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Continuing on page 4 of the public meeting agenda and the pages that follow, it is recommended that the commission adopt the recommendation in the matter pertaining to Center Park Historic District, Inc. At the top of page 4, it should be noted that the next matter pertaining to Patrice Harris versus Pico Energy Company has been postponed until the next public meeting, which I believe is January the 18th. The recommendation continues for the approval of the staff recommendations in the remaining item on page 4 pertaining to the PUC Bureau of Investigation and Enforcement versus JSN Trucking, as well as all items appearing on pages 5 and 6 through and including the recommendation pertaining to the joint petition for approval of interconnection agreement involving Windstream Pennsylvania LLC, Windstream D&E Inc., Windstream Buffalo Valley, Windstream Conestoga Inc., and Broadview Networks Inc.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Commission's Bureau of Technical Utilities Services, again in omnibus fashion, it is recommended that the Commission adopt the staff recommendations, commencing with that at the top of page 7. In the matter involving the PPL Electric Utilities Corporation, the recommendation for an appointment, the approval of Ms. Brandy Snyder to the Board of Directors of the PPL Sustainable Energy Fund of Central Eastern Pennsylvania, as well as the remaining items on pages 7, 8, and the first 2 items on page 9 through and including the recommendation pertaining to the request for an annual increase in rates involving Reynolds Water Company.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the Bureau of Technical Utility Services recommendation in the matter involving the request to add additional territory, that of Waymart Borough, to the UGI Penn Natural Gas, Inc. service territory.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion? I would like to put some comments on the record. This commission has continually supported the economically prudent extension of natural gas distribution service to unserved or underserved areas. Our action today on the instant application evidences this support. I would like to take this opportunity to thank UGI Penn Natural Gas, Inc. for taking this step forward, offering natural gas service to Waymart Borough in Wayne County. This process commenced in 2014 when the state correctional institution at Waymart converted over to natural gas service. Acting as an anchor customer, Waymart SCI's demand provides the utility revenues necessary to economically extend service to additional areas in the region. Northeastern Pennsylvania produces a significant share of the shale gas in this state. Therefore, I'm happy to see more of its residents avail the opportunity to utilize this domestic resource. This expansion will allow residents and businesses in Waymart to share the benefits of low natural gas prices for heating residences and powering businesses. This application is in the public interest, and I'm very happy to support it. Any further discussion?
Chairman. Go ahead, Commissioner. Chairman, I'd like to associate myself with your comments. I think this is another great example in Pennsylvania where we're able to use an anchor tenant to expand natural gas service, not only for the anchor tenant, but also for the residents within reach.
Thank you very much. Commissioner Kennard.
And Madam Chairman, I too would like to associate myself with your comments. I'm very glad to see the Commonwealth's gas utilities taking advantage of the Marcellus shale gas play.
Thank you. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning now to page 10 of the public meeting agenda and matters presented on behalf of the Commission's Law Bureau, it is recommended that the Commission adopt the Law Bureau's recommendation in the first matter pertaining to the rulemaking to standardize the procedures and criteria for fully projected future test years. Oh, I'm sorry.
Sorry.
I turned the page.
Horizon North?
Let's go back to the previous page. I'm getting ahead of myself, and I do apologize. Turning back to page 9, it is recommended that the Commission adopt, and we're back to matters on behalf of the Bureau of Technical Utility Services. It is recommended that the Commission adopt the recommendations in the remaining 2 items pertaining to the 2018 annual price change opportunity filings of Verizon North LLC and Verizon Pennsylvania LLC.
Is there a motion to adopt the staff recommendations?
So moved?
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
And now we will turn to matters on behalf of the Law Bureau. And again, it is recommended that the Commission adopt the recommendation of the Law Bureau in the matter involving the rulemaking to standardize the procedures and criteria for the fully projected future test year.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second?
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
And it is recommended that the Commission adopt the Law Bureau's recommendation with regard to Act 40 implementation, particularly with regard to matters pertaining to the geographical limits on solar photovoltaic systems qualifying for certain requirements of the Alternative Energy Portfolio Standards Act.
Is there a motion to adopt the staff recommendation?
So moved?
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Sweet. Any discussion? I do have comments on behalf of Vice Chairman Place and myself. I'd like to offer comments. For the record, submit the comments in its entirety, but I would like to read an abbreviated version for your hearing. Before the Commission today is the tentative implementation order regarding Act 40 of 2017. Act 40, signed by Governor Wolf on October 30th, 2017, amends the qualifications to certify solar facilities under Pennsylvania's Alternative Energy Portfolio Standards Act. Today, the Commission issues this tentative order to guide the AEPS marketplace toward compliance and seeks comment on the Commission's proposed interpretations. We wish to highlight the Commission's tentative interpretation of sections 28042. In summary, these tentative interpretations would grandfather all out-of-state solar facilities certified before October 30th and permit an out-of-state solar facility not otherwise certified before October 30th to obtain certification if it provides proof of a contract to sell solar credits. While the Commission's interpretations, as outlined in the tentative order, reflect a strict textual review, the Vice Chairman and myself acknowledge that such implementation may run counter to the intent of the provisions to Act 40. Numerous iterations of legislation have been proposed over previous General Assembly sessions aiming to close the borders in a manner similar to many neighboring states. Here, the tentative order only proposes to close the borders on a going-forward basis, commencing on the date Act 40 was enacted. Review of the current supply and demand for the AEPS qualifying solar credits and capacity indicates that grandfathering all out-of-state solar facilities may result in, at best, a negligible impact on an in-state solar development. Such an outcome would fail to achieve the potential intentions of the General Assembly to foster economic development in the state, to support environmental stewardship and to instill electric reliability. Failure to effectuate the intentions of the General Assembly would conflict with the principles of statutory construction. The rules of statutory construction provide that interpretation and construction of statutes is to ascertain and effectuate the intention of the General Assembly. Therefore, in an effort to inform the record of this proceeding, we issue the following supplemental interpretations for comment. First, we propose to interpret the phrase, "a certification originating within the geographical boundaries of this Commonwealth," as a facility located within Pennsylvania having received a solar certification. Second, we propose to interpret the act to only permit certified out-of-state facilities that have entered into a contract with a Pennsylvania EDC, EGS, load-serving entity, electric cooperative, or municipal cooperative for the sale of solar credits may maintain certification until the expiration of the contract. As well, the proposed supplemental interpretations have inherently require that we address the status of banked solar credits from previously certified out-of-state facilities. We respectfully ask parties to address the handling of such credits. This supplemental interpretation would mean effectively close the borders as of October 30th, 2017. We look forward to all interested parties' comments on the tentative order and these supplemental implementation proposals. We hope that these comments will help frame the Commission's understanding of the General Assembly's true intention for this section of Act 40.
Thank you.
Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Turning now to matters presented on behalf of the Commission's Office of Administrative Law Judge, it is recommended that the Commission adopt the initial decision of Deputy Chief Administrative Law Judge Cheskis in the matter involving the PUC's Bureau of Investigation and Enforcement versus Pine Road Natural Gas Company, Inc.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Vice Chairman Place. Any discussion?
Madam Chairman, I have a conflict statement that I would ask be entered into the record as if I had fully read it.
Thank you very much. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt ALJ Gould's initial decision in the matter involving Michael McLean versus Philadelphia Gas Works.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? I do have a comment to place on the record, and I will read it in its entirety. Before the Commission today is the complaint of Michael McLean, requesting a payment arrangement. The ALJ denied a payment request for $1,216.82 of the $1,389.64 arrears that was not part of the complainant's customer responsibility program arrears. A CRP arrears cannot be subject of a commission payment arrangement under Chapter 14. Chapter 14 gives this commission the discretion to grant a customer, in most cases, only one payment arrangement. I do not agree that a poor payment history automatically should bar the commission's exercise of that discretion because every payment trouble customer's circumstance is unique. Here, however, the ALJ correctly denied the one payment arrangement that we should normally grant even when there is a poor payment history. The record shows that this complainant paid nothing for 3 of the 5 years from 2011 through 2015 that the respondent provided service. Absent extenuating circumstances or some unreasonable explanation for why the complainant paid nothing, as opposed to any portion of the $20.28 monthly average that was accruing over 5 years, no payment arrangement is appropriate. By the same token, the complainant's limited income of $733 in Social Security disability benefits, coupled with an average monthly accrual of an arrears of $20.28 per month, demonstrates the importance of addressing what this commission determines to be affordable utility service for Pennsylvania's lower-income utility customers. Any further comments? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended in the next matter involving the complaint of Heather and Norman Furnell versus West Penn Power Company that the commission adopt Deputy Chief Administrative Law Judge Cheskis's initial decision.
Is there a motion to call up this matter for consideration?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion?
Chairman, I do have a motion on this matter.
Commissioner Coleman.
I'd ask that my motion be entered into the record as though I read it in its entirety. Before the commission is the initial decision that grants in part and denies in part a formal complaint filed by Heather and Norman Furnell against West Penn Power Company. Specifically, the decision grants a payment arrangement for arrearages that accrued when the complainants were not enrolled in West Penn's Customer Assistance Program, or CAP, and denies a payment arrangement for arrearages that accrued when the complainants were enrolled in the utilities CAP. According to the record, the complainant's outstanding account balance at time of hearing was $13,596. Of this balance, $8,200 accumulated when the complainants were enrolled in West Penn's CAP. Consequently, the case involves mixed arrearage in which the outstanding account balance at issue includes both CAP and non-CAP arrearages. I agree with the decision to deny the request for a payment arrangement for the CAP portion of the arrearages owed to West Penn for the reasons set forth in the decision. However, I do not agree with the decision to grant a payment arrangement for the non-CAP portion of the arrearages owed to West Penn. Although the commission may establish a payment arrangement for those non-CAP portions of the mixed arrearages, I don't believe that the commission should exercise such authority here, given that the complainant's poor payment history. The record demonstrates that during the 4-year period from May 2013 through April 2017, the complainants made only 5 payments to West Penn. In granting a payment arrangement for the non-CAP portion of the arrearages here, the initial decision reasons relevant commission precedent, Hewitt versus PICO, Dorsey versus PGW, do not apply because the complainants never received a commission order payment arrangement for their outstanding West Penn account balances. However, I believe that Hewitt and Dorsey cases are applicable. Like the Furnells, the complainants in those cases never received a prior commission order payment arrangement for the arrearages at issue either. Therefore, I do not believe that Hewitt and Dorsey cases are distinguishable in the manner alleged by the decision. Therefore, I move that the initial decision be reversed in part consistent with this motion, and the Office of Special Assistance prepare an opinion in order consistent with this motion.
You have heard the motion of Commissioner Coleman. Is there a second?
Second.
Second by Commissioner Kennard. Any discussion on the motion? Vice Chairman Place.
All right. Madam Secretary, I'd like my statement to be entered into the record as if I had read it in its entirety. Frequently, consumer cases come before the commission involving similarly situated low-income families who are in a cycle of debt or face mounting bills for essential utility services that has led to extremely high arrearages, in this case in excess of $13,000. In many of those instances, customers have come before the commission asking for assistance after payment arrangements or negotiations with the utility have been unsuccessful. The Furnells are not unlike many cases we have seen where consumers are requesting for the first time a payment arrangement from the commission. When a customer requests a commission-based payment arrangement, many factors are considered in commission review of the request. While the commission has discretion as to approval of a request for payment arrangement, the arrangement may not include amounts accrued while a customer is enrolled in a utilities customer assistance program. In many instances, the customer's pre-cap arrearages may be the bulk or the entirety of the debt, so a commission-based payment arrangement is an effective tool in ensuring timely payments, increasing utility receivables, and reducing or eliminating entirely past-due account balances. This case is unusual in that the majority of the Furnell's debt, $8,200.53, results from their time while enrolled in West Penn's low-income customer assistance program. Originally, the Fresnels were enrolled in West Penn's low-income payment and usage reduction program, during which time they were paying a utility bill of approximately $40 a month. Then, in 2014, the Commission approved West Penn's revised Universal Service and Energy Conservation Plan, which discontinued Light PERP, and the Fresnels were subsequently transferred into PCAP, West Penn's new low-income assistance program. When the Fresnels were enrolled in PCAP, they were income eligible based on their household size of 6 people and monthly income of less than 50% of the federal poverty income guidelines to receive a maximum bill credit for non-heating customers of $80. This maximum $80 bill credit was applied to their average monthly bill of $490. Even with the bill credit, the average $410 monthly bill represented 51% of their disposable income of $800. I'll repeat that, 51% of their disposable income of $800. During their time enrolled in the new PCAP program, their monthly bill often exceeded their entire monthly income. The Commission's CAP policy statement indicates that maximum payments for electric non-heating customers should not exceed 2 to 5% for a household with income between 0 and 50% of federal poverty guidelines. The Fresnel's energy burden exceeds this, rising at times, as noted, to over 100% of their income. However, further complicating the issue is that West Penn is offering, to the benefit of the customer, an annual maximum amount of CAP credits exceeding those requirements outlined in the policy statement. Although the company's program offers a benefit above what is required, it still provides a bill that far exceeds the recommended amount for percentage of income. On its face, it is unsustainable for a family while enrolled in a utility customer assistance program to incur bills that are at times represent more than their monthly take-home income. Although West Penn did act in accordance with its commission-approved plan, the resulting payments were not affordable, clearly, a point which the Fresnels themselves brought to the attention of the Commission on several occasions, having contacted the Commission indicating their payments were not affordable and asking for a commission-based payment arrangement. If granted, taking guidance from the payment arrangements provisions in Chapter 14 of the statute, the maximum payment arrangement length would be 5 years or 60 months. This 5-year payback period would result in a $90 per month repayment schedule, in addition to the amount of their monthly bill, which is averaging $490, with seasonal fluctuations, of course. The arrearage payback amount, including monthly charges, represents 61% of the Fresnel's current monthly income of $800, which is almost and certainly outside the bounds of what is affordable. However, this is not a reason to forego the payment arrangement in its entirety, as it is part of the solution for both West Penn Power and the Fresnels. I agree with ALJ Cheskis's initial decision in this case in granting a commission-based payment arrangement for the Fresnels' non-cap arrearage. Under the statutory authority provided to the Commission, we can grant commission-based payment arrangements, and this family is clearly payment-troubled and struggling financially. ALJ Cheskis indicated that substantial record evidence demonstrates that Ms. Fresnel has satisfied her burden to demonstrate that she is entitled to a commission-ordered payment arrangement. ALJ Cheskis further reasons the Commission has recently determined that payment arrangements will not be allowed for the portion of the arrearages that do not accrue while in a customer assistance program where there is a poor payment history and an inability to keep prior payment arrangements. However, he specifies that these cases do not apply to Ms. Fresnel, and as such should be granted a commission payment arrangement. For the above reasons, I feel strongly, as did ALJ Cheskis, that the Commission should exercise its authority to issue a payment arrangement in this case, and I also strongly encourage the West Penn Power to consider re-enrolling the Fresnels in the Customer Assistance Program and any other assistance programs for which they are qualified, with a focus on calculating an affordable payment. Though the Fresnels do not dispute the total amount owed, the sizable arrearages built up during their tenure in the PCAP program is indicative of the systemic programmatic issues and highlights the reasons for the Commission's evaluation of the broad umbrella of universal service programs and hope that cases such as this do not arise in the future. I mean, note the human cost of this. This is a family of 6 with 2 disabled parents and 4 children in the household, and we're likely making them homeless. Therefore, I dissent.
Thank you, Vice Chairman Place. Under further discussion, I do have a joint statement, Commissioner Sweet and myself. You have heard much of the facts, both outlined in the motion of Commissioner Coleman as well as the statement of Vice Chairman Place. So I'm going to submit our comments for the record in its entirety, but I am going to place some comments generally to let you know what our statement are, not our motion, but our statement. We support the motion by Commissioner Coleman in this manner, but we do so reluctantly. Chapter 14 gives this commission the discretion to grant a customer, in most cases, only one payment arrangement. We do not agree that a poor payment history automatically should bar the commission's exercise of that discretion. Every payment troubled customer circumstance is unique, and the relevant commission precedent on these matters reinforces rather than limits our flexibility in granting one payment arrangement pursuant to our code. We are troubled by the fact that Mr. and Mrs. Farnell have such a large arrearage. You've heard the amount, over $13,000. While the commission has discretion to grant a payment arrangement on the non-cap arrearage here, we do not believe that in this case, it is in the customers, the companies, or the other ratepayers' interest to grant an unaffordable payment arrangement. We continue to encourage our utilities to step up their marketing efforts on universal service programs, budget billing, and energy efficiency to prevent any customer arrearage from becoming unmanageable. We also look forward to this commission's continued dialogue on the issues of cap affordability. That being said, West Penn and other utilities have much more flexibility under Chapter 14 than the commission does when it comes to granting payment arrangements. We would also ask that our utilities work with their customers who fall behind on payments when possible. In the spirit of our Prepare Now initiative, we asked our utilities to do their utmost to educate customers, especially those on limited and fixed incomes, about programs to help heat their homes or pay their energy bills, such as the Customer Assistance Program, the Low Income Usage Reduction Program, the Federal Low Income Home Energy Assistance Program, and budget billing. Any further discussion?
Madam Chairman, I add something to our statement. It's a little bit ironic here in one sense that I agree with almost everything that Vice Chairman Place said, except, as was just stated in our joint statement, we kind of disagree with the practical result. This is an unsustainable situation for this family. Unfortunately, there are thousands of these families, and most of them do not appear before us and are not seeking formal relief from the PUC. This is a bigger, broader societal problem, and granting this particular payment arrangement won't do anything to help this particular family because, as was stated, it's unsustainable. So I'm going to vote in favor of the motion, although I don't agree with most of the analysis by the proponent of the motion. I do believe that we retain, as the chair said, significant flexibility based upon the cases that were outlined. But just as a practical matter, in this case, in exercising that discretion, it just does not appear to be anything that is all helpful for the PUC to intervene with an order that really will not ultimately make much difference. As Vice Chairman Place said, we do have a process in place, which was supported by all 5 commissioners at the time, to seriously examine the programs that are made available through utilities and through the commission to see what else can be done and can be done in a better, more efficient, and more effective way for families like this particular complainant. But I again underscore the concern for these kinds of situations, of which we see a number, which our BCS office sees hundreds, and which sadly are a number in the thousands throughout our Commonwealth. Thank you.
Thank you, Commissioner Sweet. Any further discussion on the motion? Seeing none, all those in favor say aye.
Aye.
Any opposed?
Opposed?
The motion passes 4-1. On the matter, as just amended by the motion, Is there any discussion? Hearing none. All those in favor of the amended motion or the matter as amended by the motion, please say aye.
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 Any opposed?
Opposed.
The motion passes 4-1, noting the dissent of Vice Chairman Place.
Continuing with the presentation of matters on behalf of the Commission's Office of Administrative Law Judge, we now turn to page 12. With regard to the first matter pertaining to the application of TransSource Pennsylvania LLC to commence electric transmission service in 2 corridors in Franklin and York counties, it is recommended that the Commission adopt the initial decision of Administrative Law Judge Barnes.
Is there a motion to call up this matter for consideration?
So moved.
Is there a second? Motion by Commissioner Coleman, second by Commissioner Kennard. Commissioner Kennard. Is there any discussion?
I think, this is TransSource. I believe I
is
have a
TransSource.
motion. Yeah, I believe I have a motion.
I
Madam
call on
Chair.
Commissioner Sweet for his motion.
I ask that my motion be placed on the record as if it had been read in its entirety. Before the Commission is the application of TransSource Pennsylvania LLC for a certificate of public convenience to provide electric transmission service in Franklin and York counties and for approval of its affiliated interest agreements. This authorization is the next step necessary to carry out a project that it won the right to pursue under the auspices of a PJM plan to reduce congestion. Today's vote grants a certificate of public convenience that is limited to the general area where the project is expected to be sited. The actual siting of the project will be the subject of an additional application in the future, should TransSource decide to go forward with the project. It is in that proceeding that the questions associated with siting transmission lines will be addressed. Our vote today does not approve the siting of any specific facilities. It merely gives TransSource the ability to file future applications. Therefore, I move that the initial decision of the Administrative Law Judge is affirmed as amended by this motion. The second full number 2, that the second full paragraph on page 14 of the initial decision is stricken. Number 3, that ordering paragraphs 2A and 2B are amended to read as follows. A, begin to furnish and supply electric transmission service to and for the public within a transmission service area from the new Rice substation in Franklin County, Pennsylvania, to the Maryland-Pennsylvania border for PJM Project 9A, baseline upgrade numbers B2743 and B2752. And B, begin to furnish and supply electric transmission service to and for the public within a transmission service area from the new Furnace Run substation in York County, Pennsylvania, to the Pennsylvania-Maryland border for PJM Project 9A baseline upgrade numbers B2743 and B2752. And 4, that the Office of Special Assistance prepare an appropriate order consistent with this motion. Thank you.
You have heard the motion of Commissioner Sweet. Is there a second?
Second.
Second by Vice Chairman Place. Any discussion? I would just like to state for the record, I want to thank Commissioner Sweet for his consistent, very clear clarification that this is not addressing siting. Thank you.
You're welcome.
Any further discussion on the motion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0 on the matter as amended. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? The matter as amended passes 5-0.
It is recommended that the Commission adopt ALJ Jones's recommended decision in the matter involving Veolia Energy Philadelphia, Inc.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Place, second by Commissioner Kennard. Any discussion?
Madam Chair, I would like to just reaffirm my previous conflict statement on this matter. Phil Kirkner from my team, who was previously employed with the Bureau of Investigation Enforcement, has not advised me on this matter.
Thank you very much, Commissioner Coleman. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And it is recommended that the Commission adopt the Office of Administrative Law Judge's recommendation in the complaint proceeding involving Sharon Jameson versus Philadelphia Gas Works.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Sweet, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
Madam Chairman and Commissioners, with that concluding the presentation of regular agenda items, we now turn to the carry-in agenda. And the first matter on the carry-in agenda is a binding poll. And this is with regard to the Default Service Plan 5 proceeding of the Citizens Electric Company of Lewisburg, PA, and Wellsboro Electric Company. We remind the audience that the issue sheets which have been provided simply as a vehicle, a tool to resolve the remaining issues, outstanding issues in this proceeding. They are not fully descriptive of the positions of the parties. The commissioners have based their determinations in this matter on the full evidentiary record before it. Once the binding poll has been completed, staff will prepare an order for the commission's review and issuance prior to the end of the statutory suspension period herein. Turning now to the first item, contingency plan for DSP 5, time frame for developing replacement plan.
I have asked that we initiate a new process for this poll to give the commissioners an opportunity to make their statements before we go through the actual poll for each and every one of the items. So for the first item that was just called up, are there any comments or statements? Hearing none, I call on Commissioner Coleman.
ALJ.
Commissioner Sweet.
ALJ.
Commissioner Kennard.
ALJ.
Vice Chairman Place.
Companies.
And I will go with ALJ.
Issue number 2, contingency plan for DSP 5, time period for reconciliation of supply cost variance.
Are there any statements or comments for the record on this issue? Hearing none. Commissioner Coleman.
ALJ.
Commissioner Sweet.
Company.
Commissioner Kennard.
ALJ.
Vice Chairman Place.
Companies.
And I will go with ALJ.
Issue number 3, solar purchase power and lease agreement, solar PPA, long-term contract period.
Any statements or comments for the record on this issue? Hearing none. Commissioner Coleman.
ALJ.
Commissioner Sweet.
ALJ.
Commissioner Kennard.
Also ALJ.
Vice Chairman Place.
ALJ.
And I will go OCA.
Issue number 4, solar purchase power and lease agreement, solar PPA, compliance with Competition Act standards.
Any statements or comments for the record?
I do have a statement, Madam.
Commissioner Sweet.
Before the Commission for consideration and disposition is the Joint Default Service Plan for Citizens Electric and Wellsboro Electric Companies. Included in the joint plan is Citizens' request for approval of a 25-year-long purchase power agreement, a PPA, with DG Solar Pennsylvania, LLC. Under the PPA, Citizens would purchase at an annual fixed price the energy output of a 1.5 megawatt solar photovoltaic system that would be constructed by GD Solar on a parcel of Citizens' land. I am voting against approval of the PPA for multiple reasons, including the apparent lack of net savings to default customers for the first 15 years of the contract, the lack of solar alternative energy credits involved, and because the PPA fails to comport with the default service requirements in both the statute and the Commission's regulations. However, I would like to reiterate my support for solar energy resources and for long-term contracts, both for energy generally and for solar specifically. My vote today rejecting the proposed PPA should not be construed as a rejection of any long-term solar contracts, as I believe such contracts do have an important role to play. Such contracts enhance renewable energy development and the associated employment and environmental benefits that result. I encourage all electric utilities and renewable energy developers to continue pursuing new and outside the box ideas for incorporating renewables into their energy portfolios. Thank you.
Any further statements or comments up front? Let me just say I'd like to associate myself with Commissioner Sweet's comments. So, on the poll, Commissioner Coleman,
ALJ.
Commissioner Sweet,
ALJ.
Commissioner Kennard,
ALJ.
Vice Chairman Place,
ALJ.
and I will be going with OCA.
Should be noted, Madam Chairman, that as a result of the Commission's votes on the first 4 issues, the polled items numbered 5, 6, and 7 do not have to be voted on. We will now turn to issue number 8, that being approval of company's joint default service plan, DSP 5, with recommended modifications as being consistent with prudent mix standard of the Competition Act.
Are there any comments or statements on this issue? I would like to add a comment for the record. Wellsboro proposes a 3-year DSP, which procures energy via a mix of hourly price products and 6-month price products. Wellsboro would hold 1 auction for the entire 3-year period. Wholesale suppliers would bid on price adders to be used to translate the respective spot and forward market prices into a retail price to compare. Citizens proposes the same portfolio plus an additional 25-year power purchase agreement with a solar facility to be located in its territory designed to serve 2% of the load. I commend Citizens for proposing a long-term PPA contract. However, this distinct proposal of PPA has flaws. First, 2807E 3.2 Roman numeral 3 code, under the code, states that the long-term contracts may not be more than 20 years. 2807E 3.3 permits for an extension of a contract for a longer term of up to 20 years, if the extension is necessary to ensure adequate and reliable service at least cost to customers over time. In this proceeding, I must agree with the OCA that the record is devoid of any facts showing that the 25-year term of the PPA is necessary for service adequacy and reliability and therefore does not meet the statutory requirements. Further, Citizens' proposal to utilize the 25-year PPA does not comport with the Commission's regulations of Section 54.188A, which states, a DSP shall file a plan or amended plan for competitive procurement with the Commission and obtain Commission approval of the plan before the competitive process is implemented. In this case, Citizens commenced the competitive process seeking long-term PPA bids and chose a winner prior to filing its DSP. Citizens would have been better served by seeking a waiver of these regulations or by designing a DSP that issued a competitive process for power procurement after the DSP was approved. Last, the 25-year PPA does not include any of the associated solar renewable energy credits, or SRECs, generated from the proposed solar facility. Rather, it only includes the purchase of energy. This means the generator itself takes title to the environmental attributes of the facility, not Citizens or its customers. For all the above reasons, I submit that the proposed PPA fails to warrant inclusion in Citizens' contract mix. In Wellsboro's DSP, there are no proposed long-term contracts. I note that the record in the Wellsboro DSP provided no legitimate evidence supporting the necessity for deviating from the statute. Further, the Citizens DSP, as amended, no longer includes any long-term contracts. Therefore, neither DSP complies with Section 2807E of the Code. Given the lack of long-term contracts in both the Wellsboro DSP and the Citizens DSP as amended by the ALJ's decision, I must respectfully dissent in approving the company's DSP. Moving forward, I encourage Citizens and Wellsboro to consider filing amendments to this DSP proposing inclusion of a long-term contract in each company's portfolio. These could include PPAs, alternative energy credit contracts, block energy contracts, or future index strike contracts in excess of 4 years but no longer than 20 years. I also encourage consultation with any interested stakeholders, including those active in this proceeding, on the design of such contracts or PPAs and associated procurement procedures in an effort to foster compliance with 2807E and our regulations at section 47.118A. Any further comments or statements for the record on this issue?
Madam Chair, just quickly, I agree with your analysis, as I have in prior instances where these default service plans have come before us. And so I, too, will be voting in the negative and against the approval of the plan.
Thank you, Commissioner Sweet. Any further comments? Hearing none, let's go to the poll. Commissioner Coleman,
ALJ.
Commissioner Sweet.
I'm not sure who's your position.
Okay.
No, on the plan. I think was also the OCA's position, but clearly negative on the plan.
Commissioner Kennard,
ALJ.
Vice Chairman Place.
ALJ.
And I will be dissenting from the petition, which is your position then, Commissioner Sweet.
It's the brown sweet position.
That does conclude the binding poll, and we will continue with the presentation of carrying agenda items. It is recommended that the commission adopt the recommendation in the matter involving West Goshen Township versus Sunoco Pipeline, LP.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Sweet. Under discussion.
Took all the drama out of it.
I know. Under discussion.
Madam Chairman, I have a motion that I would ask that entered into the record and I read it in its entirety. This matter concerns an injunction previously granted by the commission against the installation of a valve on the Janet 2 property. Should I start again? Madam Secretary, I ask that my motion be entered into the record as if I had read it in its entirety. This matter involves an injunction previously granted against Sunoco by the commission involving the installation of a valve on the Janiak, I think I've pronounced that correctly, I hope I have, property in West Goshen on the grounds that it would violate prior settlement of the parties. In our October 26th order, we found that construction of the ejected 2 valve should be enjoined because the tests for interim emergency relief had been met, namely that the township's right to not have the valve installed on the Janiak 2 tract was clear. The need to enjoin construction was immediate. The injury to the public would be immediate, and the public was not injured by the granting of the stay. The underlying facts have now changed, and I propose that our prior order, based upon these old facts, be discontinued. Sunoco has now conceded that it will not install the objected 2 valve in the Janiak 2 tract or anywhere else in the township for that matter. This is a substantial win for the township. Sunoco has unilaterally resolved the main dispute, the one that spawned the injunction. There is no longer any threatened activity to enjoin, and the issue of valve construction is moot. This may or may not resolve the entirety of the township's issues, and to that end, the township's amended complaint should be heard and resolved expeditiously by this commission. Therefore, I move that the injunction issued by our October 2017 order be discontinued as of the date of the final order disposing of Sunoco's petition, that the Office of Administrative Law Judge return the matter to us for final resolution by the commission at the September 20th, 2018 public meeting. The Office of Special Assistance prepare an opinion and order consistent with this motion.
You have heard the motion of Commissioner Kennard. Is there a second?
Second.
Second by Commissioner Coleman. Under discussion. Vice Chairman Place.
Thank you very much. Madam Secretary, I ask that my statement be placed into the record as if I read it in its entirety. In his petition, Sunoco has clearly indicated, as noted, that its construction plans to locate this equipment within the limits of West Goshen Township have changed. In doing so, the provisions of the 2015 settlement agreement are impacted, and these issues are the gravamen of the township's March 29, 2017 first amended formal complaint to enforce settlement agreement. Because this change directly impacts the issues being litigated before the administrative law judge assigned to this case, I believe that the parties should have first raised this issue in the underlying proceeding and sought a negotiated amendment to the 2015 settlement agreement. In timely reaching a formal agreement reflecting the change in Sunoco's construction plans, the parties could have submitted a revised agreement requesting approval from the administrative law judge, suspended this litigation schedule, and brought the matter before the commission for final disposition. In addition, I'm having difficulties with words beginning with A today. In addition, by amending the 2015 settlement agreement with Sunoco's updated construction plans, the parties would have been afforded the appropriate protections with a written modifications provided. I firmly believe that if Sunoco had entered into successful settlement negotiations before the period of time expended to file and address this petition, their actions may have resulted in expedited treatment in the issues of this case, including the interim injunction. Most importantly, I strongly encourage the parties to settle this matter now that Sunoco has modified its construction plans regarding certain equipment originally planned to be located within the limits of West Goshen Township. To do otherwise is wasting the parties and the commission's resources. Therefore, I will be dissenting.
Thank you, Vice Chairman Place. Any further discussion? I do have comments to submit for the record. I'd like to submit them in its entirety, and I will just provide for you my concluding paragraph, which states that I do not support rescinding our prior injunction. Our October 2017 order addresses prior relevant commission and appellant decisions relating to our determination to grant the township's request for emergency relief. Most significantly, our order provides a jurisdictional roadmap for this proceeding and explains our authority over the issues presented in this case. The parties have not settled this case. The township has clearly expressed its intent to continue to pursue this action, and contested issues remain before the commission. So accordingly, I will be dissenting as well. Any further discussion on the motion? Hearing none. All those in favor say aye.
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 Any opposed?
Opposed?
And I also oppose as well. So the motion passes 3-2, noting the dissent of Vice Chairman Place and myself. On the matter as amended by the Commissioner Kennard's motion, any further discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed?
Opposed?
Opposed as well. So the motion passes, as amended, passes 3-2.
Turning now to page 2 of the carrying agenda, and the first item, it is recommended that the commission adopt OSA's recommendation in the matter involving the Aqua Pennsylvania Wastewater, Inc., Act 1329 proceeding involving the assets of Limerick Township.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion? Here. Commissioner Vice Chairman Place.
All right, thank you. Madam Secretary, I ask that my statement be entered into the record as if I read it in its entirety. Before the Commission for consideration is a petition for approval of the long-term infrastructure improvement plan of UGI Utilities.
That's the next matter.
Oh, sorry. All right, I digress. So
It's the
Trying to hurry up
gremlin in the room today.
All right, sorry.
On the Aqua case,
All right,
any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
And now, on behalf of the Bureau of Technical Utility Services, it is recommended that the Commission adopt that Bureau's recommendation in the matter involving the UGI's Utilities, Inc. Electric Division petition for approval of its long-term infrastructure improvement plan.
Is there a motion to adopt the staff recommendation?
So moved. Second.
Who said it first? Is it you?
Fine, yes.
Vice Chairman Place, Commissioner Coleman, second. Under discussion. Now you're
All
ready.
right, thank you. When I was a kid when running track, I did have a predisposition to false starting, so try to continue that in my adulthood. All right. Or presumed adulthood, if my children might note. Madam Secretary, I ask that my statement this time be entered into the records if it read in its entirety. Before the Commission for consideration is the petition for approval of the long-term infrastructure improvement plan of UGI Utilities Incorporated Electric Division. Under the initial LTIP, UGI projects investments to increase from an average of $3.528 million per year of the historic four-year period 2012 through 2015 to $7.967 million per year for the LTIP period 2018 through 2022, a nominal increase of 125%. Given such a substantial increase, it is vital that utilities provide more than qualitative assurances that the resultant increases in customer bills are utilized to efficiently enhance reliability and safety as envisioned under Act 11 of 2011. Utilities should endeavor to accurately quantify incremental improvements in reliability and safety, in addition to operational expense savings, to optimally prioritize these investments so that they are made prudently in accordance with utility rate-making principles and law. UGI has committed to conduct ongoing reviews to ensure that the programs in the LTIP are efficient and will utilize this information to determine the most cost-effective strategy for replacing its distribution infrastructure on an ongoing forward basis. Specifically, on an annual basis, UGI will review the impact to reliability that LTIP programs have been by measuring and comparing post-plan implementation reliability indices with historical reliability indices on a per feeder basis. Reliability metric performance may result in the redirection of spending to help ensure UGI meets its identified reliability targets in a cost-effective manner. While this is a good start by UGI to quantify improvements in reliability, safety, and operational expense savings, I encourage UGI to expand these efforts and to provide a quantitative evaluation of its LTIP investments, similar to that developed by PPL Electric Utilities Corporation in its second LTIP, which is the next item on our agenda today. Also, I further encourage UGI to aggregate the reliability, safety, and operational expense savings to an overall LTIP level, and to the extent possible, quantify the annual goals for these measures and include this information in its required annual reports regarding its reliability review of its feeders. This information would enable the overall LTIP to be objectively measured from year to year or on average over the years, recognizing the variations in the number of non-excludable, for example, storm events, can cause year-to-year variability in reliability metrics. Thank you very much.
Thank you, Vice Chairman Place. Any further comments? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the staff recommendation in the matter involving the PPL Electric Utilities Corporation petition to seek approval of its second long-term infrastructure improvement plan.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second?
Motion by Commissioner Kennard, second by Commissioner Coleman. Any discussion?
Yes, Madam Chair. I have
Vice Chairman Place.
Thank you. Madam Secretary, I ask that my statement be entered in the record as is read in its entirety, which seems to be redundant today. Before the Commission for consideration is the petition for approval of the second long-term infrastructure improvement plan of PPL Electric Utilities Corporation. Under the second LTIP, PPL projects investments to increase from an average of $114.2 million per year during the 5-year pre-LTIP period and $137 million per year during the first 5-year LTIP period to $180.6 million per year under the second considered LTIP. This is a cumulative nominal increase in spending of 58%. Given such a substantial increase in spending, it is vital that utilities provide more than, as I noted earlier, qualitative assurances that the resultant increases in customer bills are being utilized to efficiently enhance reliability and safety as envisioned in Act 11 of 2011. Utilities should, as I noted, endeavor to accurately quantify incremental improvements in reliability and safety in addition to operational expense savings to optimally prioritize these investments so that they are made prudently in accordance with utility rate making and principles of law. To this end, I want to recognize the efforts of PPL for developing a process that achieved this investment prioritization process. In routinely reviewing the effectiveness of its LTIP programs, program and project impacts on System Average Interruption Duration Index, or SAIDI, and System Average Interruption Frequency Index, SAFE, in addition to potential reductions on outage response costs, are compared to the overall program and project costs. Changes in reliability performance metrics are factored into program reviews, and funding may be redirected to projects that help ensure PPL's ability to meet various reliability performance targets in a cost-effective manner. PPL utilizes a project prioritization process that defines the cost-effectiveness of programs and projects to ensure effective optimization of reliability investments. PPL's methodology utilizes a dollar per customer minutes interrupted, or dollars per SAIDI minute saved metric. PPL notes that generally any project with an investment less than or equal to $3 per SAIDI minute saved is a good investment. PPL notes that other factors such as system performance, public and employee safety risk, and customer satisfaction are also weighed. Such efforts to quantify the effectiveness of LTIP investments to enhance reliability, safety, and operational expense savings should be considered best-in-class practices, and I commend PPL for their efforts to do so. At this time, I encourage PPL to aggregate the reliability, safety, and operational expense savings to an overall LTIP level, and where possible, to quantify the annual goals for these measures in its annual asset optimization plans, so that the second LTIP overall can be objectively measured from year to year or on average over the years, recognizing, again, as I noted earlier, that variations in the number of non-excludable, for example, storm events, can cause year-to-year variability in reliability metrics. I also want to recognize the good work of Commission staff and the Bureau of Technical and Utility Services and the Law Bureau for their research into these quantitative performance measures, and for the Office of the Small Business Advocate for their thorough plan review and the valuable comments that they offered regarding PPL's LTIP petition. Thank you very much.
Thank you, Vice Chairman Place. Any further discussion? Hearing none. All those in favor say aye.
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 Any opposed? The motion passes 5-0.
And with regard to the remaining item, that being the staff recommendation in the matter involving the Aqua Pennsylvania Wastewater, Inc., petition for approval of its second long-term infrastructure improvement plan, it is recommended that the commission adopt that recommendation.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Vice Chairman Place. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman and Commissioners, that does conclude the presentation of public meeting agenda items.
Thank you very much. Let me just say, as I started out with today, opening up our meeting, I said this is the 19th meeting of the Pennsylvania Public Utility Commission. It's been a long but very fruitful year. We've had a lot of changes. You can see the changes here in this bench. We had one of our beloved colleagues, Rob Powson, move on to FERC, but we have been joined with another beloved colleague, Commissioner Kennard, who has been here among the ranks of us as staff, but is now joining us on the commission. But as you see the changes up here, what remains the same is the dedication and the commitment of our Public Utility Commission staff. It's only because of the staff that we have here on the commission that we have such a great reputation. And that's reflected in all the legislative activity that we have seen this year. We know through the dedication and commitment of Commissioner Coleman, who has worked 6 years on getting one call jurisdiction here to the PUC, it finally has passed this year. But we also know it's because of the commitment and dedication of the PUC staff, and we know we will be busy with that issue this year. We also now have jurisdiction, or I think it's still in the governor's desk, to be signed with the Pittsburgh Water and Sewer Authority. Once again, I still say it is the reflection of the staff at the commission that the General Assembly knows that we can handle the work. So I would like to take the opportunity on behalf of the commissioners, they may want to chime in as well, just to thank our staff for all the hard work they have done in 2017. It's because of you that you make us look good sitting up here. And I just want to wish you as I leave, I left this message on one of my voicemails a long time ago where I said to everyone, have a Merry Christmas, a Happy Hanukkah, a Happy Kwanzaa, and a Happy New Year. It covers it all. So I just want to thank you for all your work, and I don't know if anyone else wants to chime in.
You said it well.
Okay. Once again.
Well done, Madam Chair, except I think, I'm not sure I want to call for a vote, but beloved Powelson. But anyway, to all of you and to Rob Powelson up there in the stratosphere, Happy New Year.
Thank you very much. Without objection, the meeting is adjourned.